Good afternoon, everybody. Welcome again to another session, another Q&A session. My name is Chris Justice. As you can see down below there, I'm an associate with Samfiru Tumarkin out of its Toronto offices. And as I have in the past, I'm here today to join you all in hopes of answering as many questions as I can, all things related, of course, to employment law. So maybe you've got a question about something regarding an opportunity that you're thinking about going into, rather. Maybe you've experienced something during the actual work relationship itself, or perhaps you've got a question or a concern about something on your way out from a company that you worked for. Again, whatever it is, all things employment law related, get your questions in now today, and I will do my best to answer as many as I can within the time allotted. As many of you who have watched this before know, I like to start off today's session with a couple of topics that have been trending in the news, things relating to employment law that I think everyone can learn from. And the first topic I wanted to talk about actually had to do with a company by the name of Canopy Growth. They are closing down their headquarters and selling the building, the main building, to the original owner, which is Hershey Canada. And so this sale actually comes just after Canopy actually announced a number of layoffs back in February. So I thought this sort of brought up an interesting topic around what happens to employees in the case of a purchase and sale, or perhaps if an employee is told to move locations after a purchase and sale. What are their rights? What are their obligations? A lot of times, especially nowadays, there are companies, whether it's Canopy or anyone else, who are shutting down their business or who maybe are closing down certain locations of their business. And, sometimes they tell the employees that work there that they're being let go and they're being given a severance package. And in other times when, a location closes down or a purchase and sale happens, the employer will tell the employees that are currently there that they need to relocate, that they're no longer going to be working out of one physical location, but now reporting to a different location altogether. And as far as the location issue is concerned, if you're being told as an employee that you need to work from a location that's very far away from the one that you have been working at, there's a good chance that your employer can't actually require you to switch locations in that sense. Even if there is a purchase and sale, even if the location that you're working at shut down, just know that you have options in most cases, that you don't have to accept that change. And that if you do accept the change and start working out of the new location, again, could be in the context of a purchase and sale or not, it's going to be harder for then you to later go back and insist that you not work at that location. So you definitely want to give us a call, get some legal advice from an employment lawyer when it comes to employers that come to you and sort of propose changes. Again, could be location, could be the job itself, it could be your hours, and it may all be in the context of a purchase and sale. It may not be something that they're targeting you for specifically, but that also doesn't mean that the companies can get away with doing that. You will have to have signed a contract or consented in some way to that company having the ability to change your location, to change your job, to change your hours. And if not, as I say, even in the case of a purchase and sale or where a location, for example, is being closed down, you do have options. As I say, there's some individuals that are offered severance packages when it comes to a purchase and sale, or maybe if your location is being shut down, you may not be offered a job at another location, but instead be provided with a severance package. And I think that, as I always say, regardless of what the context is, if you've been given a severance package by your employer and you're being asked to sign that severance package, maybe you think it's a good package, maybe you think it's fair and reasonable. Just know that in most cases, vast majority of cases, whatever the company is offering you is not going to be fair and reasonable. You will want to negotiate. You will want to have an experienced employment lawyer involved to negotiate, because a lot of times, if not most of the time, you're often being given maybe 50 cents on the dollar, half as much of your best case scenario, especially when it comes to your standard severance packages. So definitely give us a call on that front too. If you've been given a severance package, doesn't matter what the context is, just so that we can make sure you get a fair and reasonable package. A lot of people are getting less than a month per year, less than a few weeks per year. when they could potentially be getting 4, 5, 6 weeks per year. So you don't want to assume as an employee that there's a certain rule of thumb that you're to get 1 or 2 weeks per year. It can be significantly more than that. And again, even if you may think the package is good in the first instance, you could be throwing away thousands or tens of thousands of dollars by just signing off and going your separate way. So definitely give us a call if you're in that situation. But again, that could be in the context of a purchase and sale or just in general. I've got another topic that I wanted to talk about. It had to do with former CEO of Rogers. They're suing the company itself for wrongful dismissal for breach of contract. And this particular individual, as part of their compensation, had a very big bonus component. And that's another thing I wanted to talk about today, having to do with bonuses, because a lot of people, aside from earning their base wages, aside from getting maybe some benefits, maybe a pension, they're also entitled to commissions or bonuses or incentive pays, variable pays, depending on what you want to call it. These bonuses, these commissions can oftentimes make up a very big part of your overall compensation. And a lot of people, when they are let go, when they lose their job and they ask me what they're entitled to, what's fair and reasonable, they sort of assume in a lot of cases that they're not entitled to a bonus, that, the company may have to provide them with 4, 5, 6, 7, 8 months of severance, whatever that is. But that would just be their base pay. They wouldn't get anything more than that, when in most cases, that's actually not the case. So if you are looking at a fair and reasonable severance package being, whatever number of months it is, you do want to make sure that at least you try and get your bonus over that same period of time. So for example, if your company offers you a 12-month severance package, and on an annual basis, you were averaging about $50,000 in bonuses, your base salary might be $50K a year, but that extra $50K is going to go a long way. And so again, you want to make sure that whatever package you're being offered, it includes as many different components, different aspects of your compensation, of your remuneration as possible. And bonus is just one of them. But a lot of times I will find employers tell me or tell my clients that they're not entitled to anything of a bonus, that because they were let go, because they lost their job, that they've therefore forfeited their right or their entitlement to a bonus. And there may even be a bonus plan that says something along those lines, but it has to be worded in a very particular way, the bonus plan. So even though companies do often tell people, you're not actively employed on the day your bonus is supposed to be paid out, we've let you go, and that's well before this date, so therefore we're not going to give you a bonus. As I say, in a lot of cases, they're actually incorrect, and you should be getting a bonus, or at least a prorated amount, or sort of a partial amount of your bonus, depending on how much severance is given, as well as depending on how much you made in the historical sense. Back, maybe 2, 3, 4 years, if you're averaging a very substantial bonus, as I say, you want to make sure that that's included in any severance negotiations, along with any other items that are often forgotten about or sort of pushed back on. And, these things can include benefits, pension, employee share ownership plan type stuff, obviously commissions, incentive pay, stock options. So there's a whole host of items, not just bonuses, but a number of different items that you just want to make sure are addressed when it comes to those negotiations. I've got a couple more topics I wanted to chat about regarding what's going on in the news. But before I get back to that, I'll answer some of the questions that are coming in. And again, thank you for everyone in bringing in their questions. Definitely get them in. I'll start with Carol Ann on YouTube, who is saying that they hope they can tell me how long an employer has to put you back on a work schedule after you've told them you're ready to return to work with a small accommodation. So thanks for the question, Carol Ann. It's a good scenario you've brought up, the scenario where an employee goes off on a medical leave of absence, provides the company with the medical documentation, with the information needed to sort of support that absence. And at some point, there comes a time where the employee is ready to go back to work. Maybe they're ready to go back to work without any accommodations whatsoever, or maybe they're ready to go back to work with some minor modifications of some sort. But either way, when an employee reaches out to an employer and tells that employer that they're ready to go back to work with or without accommodation, at that point, the employer has to look to accommodate that employee. The employer has a duty to accommodate somebody who's coming back from a medical leave of absence up to the point of undue hardship. So it's not to say that companies have to accommodate literally any and everything that an employee asks for, but for the most part, they have to accommodate a very large amount of accommodation, so to speak, before they can start claiming that it's too much or that it's an inconvenience or a burden somehow. So Carol Ann, if you've already notified your employer that you're ready to return to work, and they haven't responded to you as far as having you come back, you definitely want to give us a shout. There's no exact set time on how long, let's say, an employer has to respond. But if you've reached out to an employer, for example, and you've provided them with a sick note with some small accommodations that you believe should be accommodated and shouldn't affect them in any major way, I would like to think that your employer is going to have some kind of a response for you within a week or two. I would say that if you're not getting a response after a couple of weeks, maybe you've sent a couple emails to let them know you're ready to go back, then as I say, you may have to get a lawyer involved and get a lawyer to contact the company, because an employer, they can, I guess, spend some time in trying to organize a return for you and get you back onto the schedule. But yeah, if you're waiting weeks and weeks and weeks and there's no response, then there could be a case where the employer is either just trying to ignore you, or maybe hope that you go away, or dismiss your concerns. Maybe the accommodation that you've asked for, they think is too big or too much of a burden to them, which is unfortunately a lot of times what I come into contact with myself as a lawyer. Are employers that just don't want to offer the accommodation because it's an inconvenience. But they don't realize, or maybe they do, but they don't realize that, minor inconveniences or just an inconvenience or even a financial cost is not going to be enough for most employers to just simply not accommodate you. So if there's a potential issue there, Carol Ann, where they're not accommodating you, you could be entitled to potentially a lot of compensation, because you're looking at obviously your normal severance rights in the event that your employment's been terminated, but you're also looking on top of that at potential human rights concerns. If there's a medical issue and you're not being afforded the accommodation, then there's a good chance that if it weren't for you going off on the medical leave or sick leave to begin with, none of this would have happened. And so if you can show that, then the employer is actually going to be in a lot of hot water from a human rights perspective, on top of whatever their severance obligations for you would be. But I would say, Carol Ann, before you have any further major communications with your employer, just because there are some things you might say that could hurt you, it'd be good to give us a call so that at least we can kind of guide you through your communications with your employer, make sure that you do and say everything that you need to. And then at that point, if it's going to be in the employer's hands, how they want to decide or determine what they're going to do, whatever would flow from there. So if they call you back and they fit you back in the schedule and they're able to make the accommodation, that could be an ideal scenario. But if they're not going to make an accommodation or give you the runaround, then you may have to start considering what a potential exit from the company looks like, and also what kind of compensation you'd be looking at. But I thank you for the question. As I say, it's a situation that I come into across a lot, and it's important that people know what employers have to do when it comes to their duty to accommodate someone's return. But thanks again for the question. I've got another one in from Brennan on YouTube, who's saying that they've been working as a contractor for the last 15 years. The company or their employer has told them that their contract will not be renewed in October, and Brennan's asking whether or not he's owed any severance. So based on that brief little blurb, Brennan, it does seem to me like you are owed severance, and that you're owed severance based on being there for 15 years. A lot of times employers will hire employees based on fixed term contracts. So instead of just saying, you're going to work for us in this role and we hope that we have a great future together, they'll just have you sign maybe yearly contracts that are 12 months fixed terms each. And every single year, just renew it. Well, it may be the case that your contract is technically over in October, but the fact that you probably have signed a number of these contracts over the years would likely suggest that you would normally expect to continue working beyond the first 15 years that you've been there and past the October deadline. So I would imagine in a lot of cases, employers will say that you got a contract, it says you're working until October, and as of October, they're going to go their separate ways and they're not going to pay you anything, which, yeah, as I say, in a lot of cases, and in most cases, is wrong. So, and then the other question would be whether or not, Brennan, they consider you to be an employee. You use the word contractor. A lot of times, individuals get labeled a contractor, but in reality, in the eyes of the law, they're actually employees. They're not contractors. And so I find that a lot of times employers will basically miscategorize or misclassify you as a contractor just so that they can potentially avoid having to pay you severance, because there are certain individuals, certain workers who are considered independent contractors that aren't actually entitled to severance. But it's relatively rare for that to be the case. Again, you could be called an independent contractor. You may even yourself think you're a contractor, but the law will decide who's a contractor and who isn't. And as I say, fortunately, for the most part, most of the cases I come across where people are being labeled a contractor, they're actually not. They do have severance rights and they are owed severance. And again, if you've been there for 15 years, signing contract after contract each year, the company may think that they don't owe you anything, but there is a very good chance that the law would just consider you to be an employee of an indefinite duration, and getting severance befit for a 15-year person, which as 15-year employee, you could get you could potentially get a year and a half of severance. So again, that's a situation you want to give us a call about, Brennan, because you want to make sure that you are communicating with your employer in the right way leading up to your last day, if it is going to be October. And then if they are going to cut ties with you in October, again, you want to make sure that you get a fair and reasonable severance package in your situation. But definitely give us a call. Maybe we can kind of flesh out some further details with you, look at maybe a contract you would have signed, and kind of review the communications that have been going between you and your employer. But thanks for the question as well. It's a good situation and definitely something you should give us a call about. I've got another question in from JX2 on YouTube, who's asking whether or not employers are allowed to discipline or dismiss an employee that's trying to unionize. And they're asking as well about the repercussions in BC. So I practice in Ontario, so I can't speak specifically to BC. But I think that if an employer attempts to discipline or dismiss an employee that's trying to unionize, there's a very good chance that that could be seen as retaliation, as some form of reprisal. I believe in general, to the extent it can happen, unions can be created, employees can band together and unionize. It may depend on how that's happening, how those employees are trying to unionize. But I think the simple fact of an employee or a group of employees trying to unionize, having there be some form of discipline or dismissal in general could be a problem. But I think it also, as I say, depends on how you're going about it, basically, how you and or other employees are going about it. If it's causing disruption, if it's not, there could be indirect issues with creating a union that could pose problems for the company and that might be subject to discipline. But I think it's something that would probably need to be fleshed out a bit more in a consultation just to get the full scope of, when these efforts began to try to unionize, what was done, what, if any, retribution or retaliation the employer has, committed or conducted in response to that before I can really give a more definitive answer. JX2 is also asking whether or not the employer and the employer will be bound by a pre-union contract going forward. I think that if you have a contract with an employer and you're non-unionized, then in large part, that contract is going to form the basis for many aspects of that relationship. I think that if you subsequently unionize afterwards and a union's formed, usually there'd be a collective bargaining agreement, and that would be the key document that would probably determine issues moving forward. So I don't think that you'd be able to necessarily rely on a pre-union contract if you've now entered into a unionized situation. But until that happens, yes, there could be the likelihood that any pre-union contract would have to be bound by. So whatever the terms of that contract are, depending on what that contract would say, that would definitely likely be the case. But again, you'd want to give us a call, maybe send us the contract. We can set up a consultation and go through all of this in greater detail. I've got another question in from Bernie on YouTube, who's asking, or saying rather, that they've been restructured. I guess that they've been let go due to their former employer based on a restructuring, which is a relatively common thing. They've received 12 months of a severance package, which is to be paid out monthly. They're 64 years of age, and their last pay is coming in November of this year, and they're asking whether they can collect employment insurance. So first of all, Bernie, I don't know how long you've been at that company, but it could be the case that a 12-month severance package is not enough. So number one, you want to give us a call first and foremost to make sure that the 12 months itself is adequate, because at 64 years of age, if you've been there for a long time, for all I know, you could be entitled to 16, 18, 20 months, let alone just 12. So that's number one right off the bat that I would want to say, as I say, for reason for you to reach out to us. Number two, whether or not you can collect employment insurance. So if you're an employee and you've lost your job and you've been offered or given a package, let's say in Bernie's case, it's 12 months. If I lose my job, say January 1st of this year, and my employer ends up paying me 12 months severance, so paying me out for the full year of 2023, I'm not going to generally be able to collect employment insurance over that period of time, because I will have suffered no loss, no financial loss. Employment insurance is generally aimed at compensating those who have lost their employment and who have not been given severance, or maybe not been given enough severance. So for the first 12 months, if that's what the offer is, or that's what you get, you're not likely going to be able to collect any EI. There may be the possibility that you can collect EI after those 12 months are over, or whatever the severance package ends up being. There may be an ability for you to apply to EI early on, and then later on start collecting some benefits after that time frame. It's just not generally possible to collect both EI and severance that would cover the same period of time, simultaneously. That's all. I've got a some follow up from Carol Ann, who had earlier asked a question about returning to work, giving her employer a small accommodation from a sick note from her doctor. And Carol Ann is saying it's been 7 weeks since she's asked to go back. There's been no response. She's asking for a chair some of the time. So Carol Ann, I think based on what I said earlier, if it's been 7 weeks and there's been no response from your employer about providing you with a chair, I think just give us a call. It's probably going to be the case that either they just hope you go away, or they're trying to dismiss it, or they don't want to give you the chair. But in general, a chair is not going to constitute such a high burden where the employer is now, able to get out of its obligations otherwise. So you definitely want to give us a call, because it seems like it's been way too long. And I think without further action, especially from a lawyer, you're likely just going to get, the runaround for more weeks. So give us a call. We should be able to do something and help you out, Caroline. So thanks for clarifying that. I've got another question in from Erica on YouTube, who's saying that the company that they work for has pressured them to come back to work full time, and this is against doctor orders, or be let go. The company says there's a new policy saying there's no part time. Okay, so again, this could be another situation, Erica, where an employer is failing in its duty to accommodate, because again, you are being given doctor's orders to not work full time, but instead work something less than that. And the company is going to have to show that it would be such a huge inconvenience, such a huge burden to have you work less than full time. A lot of times I have scenarios where companies will say to my clients, Chris, unless your client can come back to work at 100%, we don't want him back. maybe he's able to come back and do 95% of his job or 90% of his job or 90% of his hours, whatever it is, but a good chunk of his job he's able to do. And he's just asking, with his doctor's support, for an accommodation on a lower amount of time for maybe a brief period or a certain amount of time. So maybe not working part-time for the rest of their lives, but maybe a gradual modified return to work type thing where you're not working full-time, but you're slowly building up. And a lot of times in general, employers saying they want you back at 100% and not a percentage less, that's not going to constitute them going through undue hardship. Oftentimes it is another scenario where the employer just doesn't want to accommodate, even though it's possible to accommodate for whatever reason. Maybe they feel as though it wouldn't be fair to give you lower hours compared to others, and they want to treat everyone equally. But the fact of the matter is sometimes there are people that need accommodations, that need certain treatment that's different. And again, as long as you've got the support of your doctors and you've got medical documentation to back it up, that's the first step. And then at that point, it's in your employer's hands as far as how they want to respond. And as I said before, an employer that doesn't accommodate you is risking having to pay you not only your severance and essentially letting you go, but also human rights compensation on top of that. Erica, it seems, as you say, you're being pressured to sort of come back full time or otherwise be terminated. It could be a bit of a time crunch for you. So I'd say definitely give us a shout. We can set up a consultation and kind of talk through whether or not you should communicate further with your employer, depending on if you want to keep the job or if they are going to let you go, at least give you advice on kind of what you're looking for, what your options are. So definitely give us a shout. But thanks, Erica, for the question. I've got another one, a follow-up note from Brennan. Brennan was an earlier commenter who had talked about being a contractor for the last 15 years and his employer saying that his contract won't be renewed in October, wondering if he's entitled to any severance. And he did confirm that they sign contracts annually, full-time work. So again, if you're in a situation like Brennan, where you may be signing annual contracts year after year for fixed terms, and at some point your employer says, this is the last contract we're going to give, and we're not going to pay you anything because it was for the fixed term, give us a call. There's, again, a good chance that you're owed severance that would be fitting of a 15-year employee. So yeah, Brennan, definitely give us a shout. I'm sure we can help you out there. I've got another question in from Helen on YouTube, who's saying they complained about bullying and harassment in the workplace. A manager stopped the bullying and harassment for a while following this complaint, but then retaliated after 5 months. No internal investigation was done, and Helen's asking what law applies and if they can get an extra remedy. So I think, Helen, number one, it's good to complain about bullying and harassment if it's happening. You want to put your complaints in writing. You want to make a record of it, and it seems like that's what happened, and it did stop the issue for a while. But then you've got retaliation after. So I guess the question would be, what form of retaliation is it? And have you brought that complaint or those concerns to the employer in the second case? So the retaliation aspect. I think that if you bring a complaint and the issues stop, but then they start persisting again, I think it would be good for you to then reach back out to the company or their HR and actually request a formal investigation or at least file another formal complaint regarding the retaliation. That should generally be something that the company investigates. And if it hasn't happened yet, then they could be failing in their duty to investigate these legitimate concerns. If they have failed in their duty, if you have asked them to investigate the retaliation and they've told you no, then they could fail in that duty. They may have to pay you your full severance. They may have to pay you additional compensation on top of your full severance. So there could be a lot of issues here with that employer, depending on why exactly there was no investigation done and what the response has been and what exactly you communicated to them about retaliation. So I would say also in this instance, Helen, you want to give us a shout, give us a call. We can kind of go through everything that's happened so far. We can go through all the discussions that have taken place and tell you exactly what you could be entitled to, because there are things like the Occupational Health and Safety Act, which says that employers have to keep their offices or their work environments free of toxicity, basically free of harassment, free of bullying, free of intimidation, free of retaliation. So again, if this has been addressed and not addressed by you rather, but not investigated by them, they could be in a lot of hot water and you could be looking at potentially a lot of compensation. That's going to be my time today, everyone. I thank you very much for getting your questions in. If you do have any questions going forward, obviously I'm going to be back to answer more, so stay tuned for that. But also, we've got another one down below there. You see live 1 o'clock Eastern. Lior Samfiru is going to be doing this. So that's this Wednesday, just 2 days from now. So any questions I couldn't get to, if you can join that Q&A, Lior himself, I'm sure, would be happy to answer. But as far as today is concerned, I'll be signing off. I thank you again, everyone, for your questions. Hopefully you have a great rest of your day, and do take care. All the best. Bye for now.